Madam City Clerk, would you please call the roll?
Belt.
Here.
Boren.
Here.
Carlson.
Here.
Decker.
Here.
Hammond. Hammond.
Here.
Hammond.
Here.
Heidemann.
Here.
Koth. Here. Hiddleston. Here. Matichak.
Here.
Rindfleisch.
Here.
Raisler.
Here.
Sampson.
Here.
Van Akkeren.
Here.
Vanderweel. Here. And Versi.
Excused. Let's all please rise for the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I will entertain a motion for approval of the minutes from the August 3rd, 2011 meeting.
Second.
We have a motion and a second to approve the minutes from the August 3rd meeting. Is there any discussion? Hearing no discussion, all in favor?
Aye.
Opposed? Chair votes aye. Next thing on the agenda is the public forum. I think the way we're going to do this, if there's anybody against that wall that wants to be heard, we'll hear them first. Then we'll start with the section right behind the media here. In the front row, we'll work our way back, and then we'll start out on this side, and we'll do the same thing. So if there's anybody else, if there's anybody on this side of the wall that wants to be on the wall that wants to be heard, please raise your hands. The first person can come up. And when you come up, if you would please give the city clerk your name and your address, please. Excuse me.
Good evening, Tom. Could you
Hi.
give us your whole name, please?
Okay, Thomas Bowers, B-O-W-E-R-S,
And your address?
2120 North 36th Street.
2120
2120
North.
36th.
And tonight you will have 3 minutes.
3 minutes.
Yes, sir.
All right, I'll talk fast. Okay, well, thank you for allowing me to speak tonight at this Committee of the Whole meeting. I have just a couple of things to add to the pot of fire. Number one, I would like to thank past Alderman Vicki Meyer. Vicki Myers brought up about 3-4 years ago when this council tried to censure her when she called Mr. Ryan a drunk. She had to go and hire an attorney, so I would apologize on behalf and of not of the council, but on citizens of Sheboygan for calling Mr. Ryan what he really is. In addition, I'd like to read to you a letter that was sent to me by a loyal city worker. This was while I was in office, and I didn't think it appropriate at that time that I read what's in it. Dear Alderman Bowers, it would be of interest to you to know that Bob Ryan has been talking ill of you, commenting that he would rather have Alderman Meyer, as bad as she was, back rather than an old, stupid idiot like you. Ask Bob Ryan if he said this. Watch his face. As he lies to you and claims he did not make this statement. Keep up the good work. We have faith in you, and God bless you. Now, the people did not sign their name, but since then I have talked to a couple of city workers, and one male and one female. So this was a collective letter, and they told me basically what was in here. Also, another thing I would like to bring up, on the Sheboygan Press Internet, there's been some comment about Alderman Rindfleisch, that he's behind this entire thing. Now, I've known Eric for 3-4 years. He's always been honorable, and I can tell you that he is not one that instigated this at all. Everyone claims he wants to be mayor. I think it's probably further from the truth. He will probably accept it when this is completed, but believe me, he is not one that went out and entertained this job. Now, for my last thing, I would like to submit to Sue Richards, to the Sheboygan Common Council, a charge is submitted in accordance to Wisconsin Statute 1712, 1716, regarding the removal of Robert Ryan as mayor of the city of Sheboygan. And Sue, it's been notarized. Can I give this to you now?
Yes, you can, and your 3 minutes are up, Tom.
Pardon? 3 minutes are up?
Yes, they are.
All right.
Oh, boy. Oh, boy.
Thank you.
Thank you, Mr. Bowers. Next.
Hi, can I have your name, please?
Sarah Euler?
Sarah, is it S-A-R-A?
Yes.
And then O-I?
O-Y.
O-Y.
Leon.
Okay, Sarah, what is your home address?
312 Ontario Avenue.
312 Ontario. All right, ma'am, you will have 3 minutes.
Okay. Thank you for letting me talk at this meeting. As I know the mayor, he's a good mayor of Sheboygan. Yes, he does drink, but my opinion is a lot of people have problems in Sheboygan, and I think he should stay as mayor because he's helping a lot of Sheboygan out, and a lot of the people in Sheboygan rely on him as someone to talk to. That's all.
Thank you, Sarah.
Yeah.
Thank you, ma'am.
Yep.
Anybody else against the wall that would like to speak? And we'll start in, Mr. Longmiller. Thank you.
I'll change the subject for a minute.
Chase, could you give us your full name,
Chase Longmiller,
your address?
2611 Rolling Meadows Drive,
Rolling Meadows.
Rolling Meadows.
Okay, and you will have 3 minutes, sir.
Good evening, everyone. For those of you who don't know, my name is Chase Longmiller, and I'm president of the Sheboygan Firefighters Union. While 3 minutes isn't enough time for me to cover all the standards and facts that support why the Sheboygan Fire Department needs to maintain its current staffing levels, I'm sure that Chief Furman will as he gives his presentation later. However, I would like to say a few things which I hope you will help make in making the right decision tonight or next Monday. When you choose to eliminate firefighters, close stations, or shut down apparatus, you are reducing the ability of the department to respond effectively and efficiently. Remember, a fire doubles in size roughly every minute. This exponential growth is why small, seemingly manageable fires quickly and aggressively can consume a home. It is why an unattended candle can bring ruin to your home in minutes, or why a child playing with a lighter can cause a fire that displaces dozens of people from an apartment building. With this knowledge, why would you choose to reduce your fire protection? We hear the phrase, do more with less, from corporate leaders and government officials all the time. The fact is, you cannot do more with less unless you have developed a process that reduces the number of tasks a person must perform. Firefighting is a physically demanding task that requires accomplishing specific actions in a demanding and rapidly changing environment. Ask the chief about the recent study done by the NIST on how staffing directly affects how quickly and effectively a fire department can perform critical life-saving fireground functions. Fewer firefighters means less gets accomplished. It's not only the citizens of Sheboygan who are affected by any downsizing of the fire department, but us as firefighters as well. We rely on each other not only to extinguish fires or rescue trapped occupants, but also to be there to rescue each other if the time comes. Today's fires are burning hotter and faster than ever, and a firefighter can be a victim shortly after he or she has entered the fire due to floor collapse or flashover. The firefighters needed to rescue a trapped firefighter is usually around 12. That number there almost takes up the entire amount of people we have on a scene, and there's still a fire to be extinguished. I asked you during the chief's presentation to ask him about RIT, or Rapid Intervention Teams, and explain its function and how we accomplish it. In these tough budget times, the fact of the matter is that the fire department is a consumer of tax dollars. Firefighter salaries, the cost of apparatus, tools and equipment, and the continuous training. But the City of Sheboygan Fire Department per capita cost, along with the cost associated with the ambulance, according to the Wisconsin Taxpayer Alliance Municipal Book of Facts, is $169. And the median per capita cost in the state of Wisconsin is $178. The Sheboygan Fire Department has been able to provide the number of needed firefighters at less the state median per capita. And lastly, I'd like to leave you with this. Last year, when Chief Herman announced due to staffing shortages he was going to be closing stations on a rotating basis, we firefighters in less than 1 week were able to go out and collect over 1,500 signatures from citizens not just in Station 5's district, but throughout the city who were opposed to closing any of the 5 stations. These signatures are your constituents speaking. Please listen.
Good timing, 3 minutes.
Thank you, Mr. Longmiller. Anybody up against the wall that wants to speak yet? Otherwise, we'll start in the front row up here.
Patrick, may we have your full name, please?
My name is Patrick Gillette. I live at 915 North Avenue, City of Sheboygan.
You'll have 3 minutes, sir.
Thank you. Mr. Chairman and committee members, I'm one of the complainants regarding the removal of Mayor Ryan from office. My intent is not to damage the mayor's reputation, but rather to speak to the issue of the image of the City of Sheboygan, the office of mayor, and to the perceived reflection that the image has on the citizens of this city. Actions speak louder than words. We've all heard this adage before. We can say things and we can do things, but what we do leaves a more lasting impression. It is unfortunate we have to be here under these conditions. But whatever official progress the mayor has done for the City of Sheboygan, his personal actions have brought a greater attention to this city. Whatever positive things that the mayor claims he has accomplished during his term in office, his negative actions have far been more recognizable. His negative actions have been acclaimed, proclaimed, and attached to the image of his office, the city itself, and to the individual citizens of this city. The mayor's, and therefore the city's, negative notoriety has been broadcast on radio, television, and newsprint, not only locally, but statewide, nationally, and internationally. I'm standing here before you tonight because I feel that the mayor is incapacitated by his recognizable disease of alcoholism. He can therefore request of the Common Council that he take leave from his official capacity to treat his illness. By the mayor doing so, and with the acceptance of the Council, the mayor can, at some time in the future, resume his official capacity or again run for office. If the mayor is removed from office by the Council for cause, he's eliminated from that possibility. If the mayor hears and accepts this plea, it would save the City of Sheboygan the cost, the time, and the additional embarrassment of removing him from office. I thank all of the complainants for stepping up to be heard. I thank the chairman and members of this committee and council for listening, and I'm hoping that I am thanking the mayor in advance for his understanding and his acceptance of this plea. All of the citizens of the City of Sheboygan, the Common Council, and the mayor are responsible for promoting the best image possible for the City of Sheboygan. Thank you.
Thank you, Patrick.
Thank you, Mr. Gillette. Next.
Dulcie, can I have your full name, please?
Dulcie Johnson, 1306 North 3rd Street, Sheboygan.
And you will have 3 minutes.
Mayor Ryan is in the gallery this evening, and I would like to address my brief comments to him. Mayor Ryan, I hope you will be successful in dealing with your alcoholism. My father's brother was an alcoholic, so I know the angst and embarrassment that the actions of an alcoholic can cause. But my Uncle Ben was not an elected public official, and so the angst and embarrassment was only a concern for the family. Mayor Ryan, I hope you will accept the vote of the council and do what is right for yourself, your family, and the city of Sheboygan, which you have professed to love more than anyone else. Thank you.
Thank you, Dulcie.
Thank you, Dulcie. Next. Whoever's next, come on up, please.
Richard, can I have your full name, please?
My name is Richard W. Hartman. I live here in Sheboygan at 2423 North 23rd Street.
And you will have 3 minutes, sir.
Thank you. We have been hearing words like will, plan, shall, do this or do that. They sound like promises, but they are nothing but forward-looking statements which are used in an effort to get another chance. Forward-looking statements are often used by businesses to put themselves in better standing with the people they must deal with. And they are nothing but declarations referring to the future and often never become fact. This has proven to be the case with the issue at hand. Compassion is one thing, but to be smitten a third time, we will always be known as fools. It may sound petty to some, but it is another matter to consider. Bob Ryan has been using the city garage to store his vehicle. This vehicle is not his day-to-day transportation to and from City Hall. It is illegal to use city property for personal gain. Thank you.
Thank you, Richard.
Thank you, Mr. Hartman. Anybody in that section that wants to be heard? Yes, sir. Step forward, please.
Yes, sir. Can I have your name, please?
My name is Jeff Wessel. My address is 2517 North 10th Street, Sheboygan.
And Wessel is, how do you spell it, W-E-S-S-E-L?
Correct.
Okay. And you will have 3 minutes.
When I found out that there were 3 proposals presented to the fire chief on reorganizing the fire department, I sent an email to my alderman and asked him how much my property tax bill of $3,100 would go down for each proposal. I received no reply. About a week later, I resent the email and still received no reply. I sent a third email to him and stated that this was my third attempt to find out how much my taxes would go down, and I still haven't received a reply. I then contacted him on a third time, and he was not able to answer me that time either. After another attempt, I got a reply from him. It was as follows. Well, Jeff, I have been gone for over a week and do not check my email when I am gone. I can inform you that since you are a Sheboygan firefighter yourself, you have a misconception on taxes. First of all, your $3,100 property taxes are subsidized by the taxpayers, and you also have a misconception on how much tax money goes towards the fire department. For your records, per the City Assessor's Department and the former City Assessor, it is $501.78 per parcel that goes towards the fire department, not the $28 or whatever it was you guys were saying. I hope you understand that I am doing what is the best interest of the majority of the constituents and the taxpayers. If you would like a breakdown of what we will be saved, you can either ask your chief or wait for him to present it to the council and then ask our finance director what each will do for your taxes. I hope you have a wonderful day. Please feel free to pass my email along to whomever you like. I then emailed him back and asked, how does he know that I have a misconception on taxes? And how does he figure that my taxes are subsidized? I thought that since he introduced the proposal that he may have actually done some research on it. And I hope that he would also do what the majority of his constituents want and not the vocal minority. But I would not have any way to know this. No reply. I then sent another email asking him, what does he consider a parcel? Is he inferring that JL French, Walmart, Acuity, and myself all pay the same amount for fire service? Wouldn't it be more accurate to go on an assessed value or a per capita basis? If you were to do that, then your numbers wouldn't be as sensational to the person that has a property that is valued at $30,000. And you say our numbers aren't correct. Are you going to ask the police to reduce their department since they get $657 per parcel? When the chief presents his breakdown of the proposals, are you going to vote on it at that time? Or will the council allow time for public input? Is your per parcel number before or after shared revenue? How much money has the ambulance taken in year to date? Will you support the results of the Whitewater survey? This may surprise you, but I still haven't received a reply. Alderman Versi, when will you answer my questions?
Excuse me. Thank you, Jeff.
Thank you, sir. Next.
Yes, sir. Can I have your
Good
name?
evening. David L. Gartman, Gartman, 5509 Menning Road, Moenning.
5505?
Correct.
Okay.
09.
09, I'm
Excuse me.
sorry.
That's Sheboygan.
Okay, and you will have 3 minutes.
Thank you very much. You'll all have found a copy with Town of Wilson letterhead. I'm David Gartman. I'm chairman of the Town of Wilson, which is your neighboring municipality to the south. We have the checkerboard south side boundaries, so our things that are done in our area do affect each other. So our Town of Wilson board last few weeks ago, I like to read the statement that they sent me here to address the council and the mayor. Dear city alderpersons and Mayor Ryan, it has been brought to our attention the city of Sheboygan is in the process of reorganizing its fire protection services. The town of Wilson encourages you to be cautious in changing your structure for fire coverage. Our town board supports MABUS and neighboring communities working together with significant fires. But we are hoping that you do not restructure your fire protection services in a manner which would involve a significant increased dependency on neighboring communities. The Town of Wilson Board thanks you for your opportunity to share our concerns. Sincerely, David L. Gartman, Chairperson, Town of Wilson. I'd just like to give you a little background on how we're structured. I'd like to invite communication at any time. We will come in, or if you want to come out and speak with us. We are not a municipal fire department. We contract services. We have a volunteer 501c, the Black River Fire Department, and we also contract with the Oostburg Fire Department for a section of our coverage in the southern edge of the town. What this means is that it wouldn't be the elected officials who would have to make decisions. We own the equipment. The town residents and the taxpayers own the equipment. But the firemen themselves are a 501c. So I would encourage any input. There's 2 members here this evening that are here also, Corey Wentland and Brian Schmidt, if you want to hear from them or ask them questions or any time in the future, because they'd be the ones who'd have to come in with the mutual aid. We want to thank you for all the cooperation in the past. This is MABUS is the mutual aid alarm box system, which can affect many communities how they shift over. It's a new scheme, and it's very well done. So, you make decisions in your own boundaries. I always say that in our town, too. Your municipality has to make your decisions. But some decisions you make have consequences to the community. Community doesn't have boundaries. So I appreciate any working together or any lines of communication in the future on the challenge before you. Thank you.
Thank you.
Thank you, Mr. Gartman. Next. Anybody in the first couple of rows up here? I believe you're next, sir.
Mills, can we have your full name, please?
It is Milton R. Storm,
and I reside at 1736 Marvin Court. It's in the city of Sheboygan.
And you will have 3 minutes, sir.
Thank you for this opportunity. I will try to be brief. I have submitted a communication and a complaint to the city clerk not to remove Mayor Ryan. There are too many people that are using their own selfish emotions to make negative comments, and I don't think are valuable. I learned from my mail carrier that Jackie Duplan may live in my area. I wrote a letter in response to her editorial letter in the press, and I'm asking the President if I may read that letter, if I can find it.
As long as it's within the 3 minutes, Mr. Storm.
Yeah. Well, I'll read it at the Common Council meeting anyway. Must have dropped it someplace. Well, I do attend many of the council meetings and committee meetings. I've always found Mayor Ryan to be of a clear mind and a sound wisdom at council meetings and also at committee meetings. Mayor Ryan hosted a public forum in the police department conference where we talked about how to improve the revenue. I had the privilege of being seated next with County Administrator Adam Payne at that meeting. Again, the Mayor Ryan hosted a forum at the University of Wisconsin-Sheboygan, and I again had the privilege of being seated next to Adam Payne. I support Mayor Ryan with the plans of the Schuckert property. My father-in-law and my mother-in-law were good friends with them. My father-in-law did not drive, and Walter Schuckert did the driving when they did socializing. I thank Mayor Ryan for his plans that, or I don't know, for the plans that he has for the Schuckert property. There has been other leading citizens here who have been DWI, and one of them is the superintendent of schools, Joe Sion. I feel sorry for the loss of his son. But I would encourage him that after the darkness is over or the sadness is over and the darkness of the night is past, the next morning the sun will always rise and a new day begins. Lord willing, I hope to see you all at the council meeting Monday.
Thank you, Milt.
Thank you, Mr. Storm. Anybody else want to be heard? Yes, ma'am.
Joanne, can we have your full name, please?
Joanne M. Scribner,
And your address?
3 Seneca Trail.
And you will have 3 minutes.
Yes, probably public officials have to be very careful of their conduct in public. So I would advise Mayor Ryan, as the mayor of Sheboygan, and as my friend, to stay out of bars and taverns. I have a husband who is the love of my life, who also likes to drink, sometimes a lot. But he drinks at home, which is a good thing. Mayor Ryan has said at the August 1st Common Council meeting that if he is caught drinking in public, he would resign. I believe we should give Mayor Ryan another chance. Would you not want another chance to improve your public or private life? I know I would. 3 strikes and you're out. It's a good thing God does not look at us that way. He gives us chance after chance after chance after chance, many, many chances to repent from our sin and accept Him as our God and Savior and Lord. Anyone who speaks anonymously against anyone, anonymous sources, have no credibility with me. If you are going to voice a complaint against Mayor Ryan or any other public elected official, state your name, whether it's in print or on the air. Don't be a wimp. If someone is addicted to pornography and sends porn over the internet, at work, on the job, that person is usually fired. If they view pornography at home, in the privacy of their home, they don't lose their job because they did it in private, not in public. Now, Mayor Ryan, when he goes drinking, he's off the clock. It's not on the time clock. It's his private life. Thanks to the dastardly use of camera phones being used without people's permission or without their knowledge many times, we in the public sector and the private sector have no more privacy. This is not right. Alcoholism is not a disease like cancer or pneumonia or the flu. It is an addiction. I believe, though, that Mayor Ryan is up to the challenge of getting rid of his addiction to alcohol. Mayor Ryan has done far too many good things and made far too many good business decisions for this city of Sheboygan that he should not remain the mayor of Sheboygan. So, Sheboygan Common Council and citizens of Sheboygan, please give Mayor Ryan another chance to be the great mayor that he is. Sheboygan's on a good track. I've seen...
Joanne,
done.
3 minutes, yes, thank you.
Thank you.
Thank you, Ms. Scrivener. Is there anybody else that would like to be heard? Is there anybody else that would like to be heard? Is there anybody else that would like to be heard? Okay, I want to thank everybody for contributing to the public forum tonight. Next on the agenda, we have the chairman's comments. I don't have any at this time, but I may reserve that for later in the meeting. The next thing we have on our agenda is items for discussion and possible recommendation to the Common Council, Resolution number 42-11-12, Council Document number 716, a resolution requesting the fire chief to draft a long-range plan for the City of Sheboygan Fire Department. Please let the record show that Alderperson Vanderwilly is excused for the rest of the meeting because of a family issue. The next thing on the agenda, we have number 8, which is a preliminary consideration of complaints for removal filed to date with the city clerk. And I'm going to call on our city attorney, Steve McLean, to report on that, please.
Thank you, Mr. Chairman. First, I would say that I received...
I can't hear you. Steve? Yeah. We can't hear.
Usually I get feedback if I talk too close into it.
Speak louder.
The city clerk provided me with copies of 5 different communications that have been filed in her office and asked that I provide her an opinion as to whether or not any of those submittals constituted written verified charges brought by a resident taxpayer for purposes of triggering the removal statutes. So I did that, and to be fair, some of the process in this these circumstances gets a little out of whack. Typically, communications come into the city clerk and are introduced at a city council meeting and get referred to committees. Here, these documents have not yet been introduced into the council, so the council hasn't formally received any of them, although I know, because I looked at them, I know they're on the Sheboygan Press website and maybe many other websites as well. I don't know. But they're out there in the public. The chairman asked that I make copies for the aldermen of the 5 complaints because I don't know if the aldermen have looked at them. I did cut down half a tree to do that, and I've made copies, so I might as well pass those out. As a preliminary matter, I received an email from one of the, I can't remember which TV channel it was, I think one in Green Bay, asking what my function was in this process and whether or not it was statutorily required that the city attorney review these things as they came in before they went to the council. The answer to that is no. I was asked to take a look at them, and I did do that with the view that I would perhaps assist the council in kind of gleaning the wheat from the chaff, so to speak. I think the statute is not the clearest, and it hasn't been interpreted very often because these sorts of situations don't arise on a regular basis. So I have to say that at the outset, I have provided an opinion, and I finished it late this afternoon, and the chairman can pass that over to the city clerk. That's the original. I have made copies for the alderman of that opinion as well, and I can provide that. To the extent that there aren't enough, the news media can either get it from the city clerk or get it from our office tomorrow. The chairman asked that, I had agreed at the time we added these items to the agenda to provide my sort of preliminary review of the complaints. I did have a fair amount of time today to review them, and I'll provide my opinion as to each of them in the order that they were filed. But also, as another preliminary matter, I did not, and my office in no way is rendering any opinion as to the sufficiency or factual basis or merit of any of the charges set forth in the complaints. That determination, in my view, is within the province of the City Council. I looked at whether or not, in my opinion, these communications met sort of a threshold standard as to whether they're written verified charges brought by a resident taxpayer of the governmental unit of which the person against whom the charges are filed is an officer, i.e. a resident taxpayer of the city of Sheboygan. The first complaint was filed on August 1st by Jackie DuPont, and I'll try to go through these briefly and not read the word for word. Ms. DuPont signed what I would view as a communication or a letter. It's not notarized. There's no declaration in there that the statements contained therein are true. There's no oath or affirmation to that effect. And in my opinion, such a declaration is required as a minimum to elevate written charges to verified written charges, which is what's called for in the statute. The removal statute does not define what verified written charges are. It's pretty obvious what written is. It's not totally clear anywhere what charges are or what verified is. There is a definition, however, in the statutes under it's the Uniform Notarial Acts statute that deals with what notaries do and so forth, that defines verification upon oath or affirmation to mean a declaration that a statement is true made by a person upon oath or affirmation. So in my view, verification has to do with making it some sort of a declaration that the statements therein are true, either upon information of belief or to the best of the person's knowledge, and that there's some oath or affirmation to that effect in the document. There is an Attorney General's opinion that talks about verified written charges under the removal statute that that requirement being in place to protect public officials from having to defend themselves in removal actions unless there's a solid factual basis for the complaint. In other words, all of you as aldermen are elected officials as well. If all that was required was basically a letter into the city council, you could get inundated with complaints on a regular basis against you or myself, the city clerk, any department head, any city employee, and you'd have to deal with them. So I think the statute is trying to make it not impossible for citizens to bring charges, but to make it, to elevate the status of someone doing this, to recognize that this is not a routine sort of thing, and that there are consequences and repercussions to doing it. I reference an older Wisconsin Supreme Court case from 1950. It's not, the case isn't directly on point, but as a tangential issue, the court noted that where a statute required a verified complaint to be filed with the district attorney prior to the DA commencing an action, that Supreme Court held that the DA was without authority to commence the action without the statutorily required verified complaint. So in my opinion, what that's saying is that if the statute in the removal section says it needs to be written verified charges, that the verified has significance, and that without the written verified charges by a resident taxpayer of the city, that the council or whoever the removal authority is really is without statutory authority to act on that. The reason I say that is because the removal statute does say removals from office for cause under this chapter may be made only upon written verified charges brought by a resident taxpayer of the governmental unit. So anything less than that, in my view, does not constitute written verified charges. Now, so as to Ms. DuPont's communication, in my view, it's not verified. And in addition, I checked with the city assessor's office. First, I checked on the city's AS400 computer, which I have access to, and found that the address that Ms. DuPont gave as her residence was not owned by Ms. DuPont. So I checked with the assessor's office to determine whether Ms. DuPont owned any real estate in the city of Sheboygan or owned any property within the city that's subject to taxation, and the response I got back was no, she does not. Assuming that to be the case, I don't feel that it meets the test of coming from a resident taxpayer of the city, and therefore would not qualify, and council would be without authority to commence removal proceedings based on that complaint. Any questions on that?
Any questions from the council? So I guess the only question I would have is on Attorney McLean, and that would preclude a renter in the city of Sheboygan, according to the statutes, and from filing a complaint?
Not necessarily. I mean, it could be a renter but own other real estate in the city and pay taxes.
So in other words, just strictly if she rents that house and does not pay property taxes, then that precludes her from having this, filing this complaint.
Well, she can file the complaint.
But having it...
But in my opinion, it would not subject that communication to the standard where the council could then go forward with removal proceedings based upon that complaint.
Any other questions? Okay, thanks, Attorney McLean.
Yeah, those two issues are really what I focus on in most of these communications. The next was of Deborah Jelinek. Sorry if I mispronounced the name. That was dated August 2nd and filed with the city clerk on August 5th. Ms. Jelinek is a city resident and taxpayer, and that I checked on the AS-400 again. And also confirmed that with the assessor's office. Ms. Joink's letter is signed and notarized, and in the document, she swears that the statements contained in her letter are the truth to the best of her knowledge. Then I talk about as to whether the letter contains charges. I guess in my opinion, the short answer is that it does. I think that's it's not a very high bar to overcome, in my view, for something to be a charge. I think there's statements that the mayor lied to the council. There's various statements in there that I think can be construed to constitute charges. And in my opinion, that communication would pass the initial threshold requirement of written verified charges by a resident taxpayer of the city. The third complaint I looked at was of Marlene Reindl. That was dated August 3rd and filed with the city clerk on just the other day on August 8th. Once again, Ms. Reindl is a city resident, but based on information I received from the city assessor's office, she is not a city taxpayer and rents an apartment. And again, while her communication sets forth charges and is signed, there's no declaration made upon oath or affirmation that the statements contained therein are true. And basically, I conclude that it doesn't constitute the threshold requirements for the council proceeding to commence removal action based upon that complaint. The next one I looked at was the complaint of Patrick Gillette, dated and filed August 8th, and I see Pat back there. In my view, well, I know Pat is a city resident, and I did check the AS-400 in the assessor's office. He is a city taxpayer. His citizen's complaint is what it's titled, is signed, notarized, and sworn to on information and belief, and that the various allegations and statements contained therein could constitute charges for purposes of the removal statute, and in my opinion, it would meet the threshold standards for the council to be within its authority to commence removal proceedings based on that complaint. The final one I looked at was the complaint of Asher Heimerman, dated and filed August 8th. Again, Mr. Heimerman is a city resident. He didn't make any allegation about being a city taxpayer, and based upon information I received from the city assessor's office, he does not own property which is being taxed by the city. He notarizes, his document is notarized. The notarization, the way I read it, is basically your typical notarization, and what that represents is the notary makes a verification that the signature is that of the person that claims to be Mr. Asher Heimerman. It's not, just because it's notarized, in my view, does not make it any sort of declaration made on oath or affirmation that the charges contained therein are true, and there are no statements to that effect in the communication. So, in short, I conclude that on those two bases that the council would be without authority to commence removal proceedings based on that complaint. So on the last page, I conclude in summary, 3 of the complaints I don't think meet the threshold requirements. 2, I believe, do, Ms. Joink's and Mr. Gillette's. And I think the council could consider those as far as proceeding further with removal proceedings. And I close with a statement that while it may be within the council's authority to initiate removal proceedings upon submission of written verified charges by a resident taxpayer, the council is not obligated to do so. Such actions are discretionary on the council's part. If you do proceed, and we'll talk a little bit further about the process beyond that, but I would suggest as a threshold by the council that there be some majority vote or something to go forward with whatever it is you want to do. The statutes do provide, this is the removal statute, I should go back, is section 17.16 of the Wisconsin statutes, and it's subsection 3 that has most of the requirements. But in subsection 4, it does say that the council may, before acting upon any charges preferred against any officer, require the person preferring the charges to execute and deliver to the authority, in this case the council, a bond in the sum of $1,000 for the payment of all costs and expenses actually incurred by the city and by the removing power in the hearing and investigation of the charges. Once again, that's discretionary in my view, and it's not required that the council require that. I don't know if there's any questions as to that aspect.
And then, Attorney McLean, if there's no questions, let's move on to item number 9, the procedure in the event of formal removal process.
First, let me go back and once again, there are 2 methods that the statutes provide for non-voluntary termination of an elected official's office, at least a local elected official. Those are removal and recall. Statewide, a lot of people, not necessarily in our area because we didn't have a recall election today, but many parts of the state they did over state senators. The recall process is a very effective process. It's one initiated by citizens. If they don't like their elected official who was elected by the same people, they circulate a petition, get enough signatures, have a referendum election, and vote that person out of office if they so choose. That's sort of grassroots democracy where the individual citizens have and pursue that process. One threshold requirement is the office holder has to have been in office for at least a year. And that's not an issue in Sheboygan, because the mayor's been in office for over 2 years now, I believe it is. The other process is removal that basically puts the power of removing an elected official in the hands of the city council.
Steve, excuse me just a moment. If we could just follow up on that, the one you were just talking about.
Recall.
Pardon?
Recall.
Recall. Sue, I don't want to catch you off guard, but I know you and I talked about this a couple days ago. Would you be prepared just to go through the process of approximately how many signatures? I think it was 4,000 something, and then what the process is for the time period that the filers have to get the signatures, and what happens, and then when you project if it was a recall election, when it would take place?
Love to. Okay, with a recall election, I've done the numbers. It basically is, let's talk about the signatures first. What I do is I take 25% of the votes cast for the last gubernatorial race. In our case, I don't know, don't quote me on the exact number, but I believe it's 4,100 and something. So let's just say 4,200, just to be safe. So to recall the mayor, it would be a citywide recall election. It obviously would take more than the 4,200 signatures because you don't hand in just the exact amount you need. You would have to have over that in order to, when they come back into me, we have to verify, addresses, et cetera. So we with any candidate, always say there have to be more than what is absolutely needed. To start the process, what would happen is a person would come into our office, the city clerk's office, and they need to file a notice of intent to circulate a petition for recall. That's the first step. They also have to take out the typical campaign papers, the registration forms. For a campaign, it would be perhaps a committee, a recall committee called, recalling the mayor or recalling John Smith or whoever it is. They would take out those papers. The minute they file the intent and take out those papers, the clock starts running. From that point, for 60 days, they would have to collect the signatures, up to 60 days. When they turn the signatures in, say it's 60 days, then I have 31 days after that to verify all of the face of each of the petitions. Within that 31 days, I also have to allow the official that's being recalled a 10-day period where they can challenge before I finish my 31 days. Then we move into the setting up. If it is verified and everything, then the council would order a recall election. Then it would be a waiting period as far as when the election would actually happen. In estimating it, if it were to be a 60-day, 31-day, my guess is that the earliest the election could be would probably be sometime in December or possibly January. The mayor would automatically be on the ballot. He would not have to take out campaign papers. And then anyone else that qualifies to be the official would take out campaign papers to run against the mayor, the current mayor. And that's how it would generally go. I can't give you any more details right off the top of my head, but that's generally how it would go.
Are there any questions from the alderman on the process? Alderman Raisler.
What if there were like 3 other candidates? Would we have to have a primary?
Yes.
Okay. And that would take more time?
Yes.
More money?
Alderperson Kittleson.
Thank you, Chairman. And the cost, Sue, approximately?
This would, because we'd have to open citywide, it would be opening all of our polling locations. Typically, I estimate anywhere from $15,000 to $25,000, depending on how many people I have to hire, et cetera. Somewhere in that range. I can't give you an exact.
Thank you.
Thank you, Alderperson Kittleson. Are there any other questions? Thank you, Sue.
You're welcome.
Steve, if you want to continue.
Okay. The second option, obviously, is removal under the state statutes for city officials is 17.16. Under that process, these charges that are filed need to be prosecuted. Basically, it becomes similar to what we do with law and licensing. There's a quasi-judicial hearing held. Quasi-judicial in that it's not in a court, it's in a legislative arena. But it's sort of an analogous process to a certain extent. As I see it, at least theoretically, there's a couple ways that could work. And again, let me preface, I'm talking kind of what's in the statute and theorizing somewhat because I'm not aware of anywhere in the state where there's been a removal process of a mayor in the state of Wisconsin. Now, maybe going back a number of years there have been. I am aware of one reported case from the 70s that involved a city clerk. Sorry, Sue, but that was where there was a removal proceeding. Escapes me what community it was. But that went after the council went through their process and removed that officer. There's provision for appeals to the circuit court and up the chain to the Court of Appeals, and this particular DeLuca case went to the state Supreme Court. We're going to put the burden on you to prosecute the case. You prove it, and the council will act as judge and jury and render an opinion as to whether you proved up your case. I don't think that that is the process that's intended by the statutes, but it's not. It doesn't really talk to that. The fact that it talks about having the complainant perhaps post a bond would lead me to believe that the process is different than that, that it's not the complainant necessarily that prosecutes the charges. So the other option, as I see it, would be to hire a special prosecutor, have the council hire a special prosecutor if you chose to go forward to prosecute the charges, and it would have to be those charges that are submitted that meet the test of the verified written charges. In this case, in my opinion, again, it's just my opinion, I think there are two. The statute doesn't really get into whether or not you can either pick or choose one or the other, or sort of do a hybrid. I would assume the council could decide to go forward with both kind of at the same time and prove up the case using both of them. Again, the standard that the council has to arrive at for removal is statutory, and its cause for the purpose of the removal statute is defined as inefficiency, neglect of duty, official misconduct, or malfeasance in office. Now, those aren't further defined in the statute, and it's kind of left up to the deciding body as to what meets that standard. That's a sort of a discretionary test, I think. But I think there clearly has to be some cause for removal. And the statute makes clear it has to be by a 3/4 vote of the full membership of the council. So in this case, it would be 12, I guess, 3/4 of 16 as a minimum to remove. I say special prosecutor because, in my opinion, our office is pretty much, if this goes forward, is going to be out of the picture. I think our office has a conflict. Our authority and duty is to provide advice and counsel to the mayor and the council, which constitutes the governing body of the city, and we're not going to prosecute one of our clients, if you will. I don't think that's would meet any standards of due process, and would probably violate our office's code of conduct for attorneys. So that means hire an outside counsel to act as special prosecutor. Likewise, in my view, it would be prudent for the council, and perhaps I'm overstepping my bounds here, because, as I say, I think go forward, our office is going to drop out of this issue, but I think it would be prudent for the council to consider hiring special counsel also to represent the council in the sort of the hearing process and the procedure that needs to be followed. So that's two outside counsel, and there's certainly a cost to that, and I can't give you really any sort of reasonable ballpark figure as to what the costs of that would be. There would be so many variables, I wouldn't even want to hazard a guess. I can tell you that least from reading the Manitowoc, or the Marinette Eagle Herald, I think it is, their newspaper online, from what was in their paper, they were ballparking a similar process with their mayor at between $10,000 and $50,000 for basically outside council services. I think you'd also want to contract with a court reporter. The statute talks about hiring a stenographer, but I think if you're going to go through the process, you want to have a good record, and you should have a court reporter recording all of the proceedings.
Steve, could I just ask a quick question on that? That would preclude your staff from taking minutes like they do at our quasi-judicial hearings. When you said your department is out of it, does that include your clerical staff?
No, I don't think as far as taking minutes or anything like that.
Could they act as the court reporter?
Well, they're not court reporters.
They're not certified.
They're not court reporters.
Right.
Could they act as stenographers? Yes, and the statute talks about stenographers, but I guess what I'm suggesting is that you might want to go beyond that and use a court reporter. But again, I guess my thought is that what you may want to do if you're going to go down that route is get on board an attorney that will be representing the council and perhaps discuss with that individual how you want to work that. I think you also want to have that individual review these various charges and perhaps provide some assistance to the council as to whether you want to pursue that process based on what you have before you. Again, I'm sort of overstepping my bounds because I think that's a subsequent stage of this that I think I can't really be providing you advice on that. I'm trying to give some sort of general suggestions here as to what I see as big picture process as opposed to providing legal advice necessarily to the council in a removal action. Clearly there is no removal action yet, so I feel I can at least provide you general advice on possible procedures for going forward. There's been a question posed about whether or not the council would be obligated to provide the mayor with legal counsel at city expense. And while there may be some debate about this, in my opinion, under the statutes, the council would not be obligated to do that. I think there are two statutes that sort of say the same thing. 895.35 deals with, says that the city may reimburse all reasonable expenses which the city official necessarily incurs by reason of charges being filed and prosecuted if the action is discontinued, dismissed, or determined favorably to the officer. So that gives the council discretion as to whether or not to reimburse the charged elected official with their legal fees in the event that the matter is not successfully concluded on behalf of the council. In other words, in the event that the removal does not take place. Also, Section 6209 of the statutes, which deals with the officers of the city, has similar language. I think I brought that along. Maybe I didn't. Yeah, it is. 6209 sub 7. 6209 has the various officers of a city, and sub 7 is general provisions, and sub E of sub 7 says whenever a city official in that official capacity is proceeded against or obligated to proceed before any court, board, or commission to defend or maintain his or her official position, or because of some act arising out of the performance of that official's official duties. There is another statute called the Indemnification of Governmental Employees statute that's 895-46. And there could be some argument that would say that the city is obligated to provide counsel for in such a proceeding, but I don't read that statute to say that. See if the rationale for that indemnification statute talks about in any action or special proceeding, and then it goes on to talk about the court, if the court or jury awards damages and so forth. And I think what it covers is court cases where a city official is sued in their individual or personal capacity and a judgment's rendered that is against that official. The city is obligated to indemnify that official as long as they're acting within the scope of their employment. But the way I read that statute, it only applies to actions and special proceedings. You go to another section of the statutes in 801, I think it is, talks about kinds of actions, and it refers to actions and special proceedings as court actions. So this is clearly not a court action. So my opinion, that indemnification statute does not apply in this scenario. So the bottom line would be, in my view, that the city would not be obligated, could, but would not be obligated to pay for the mayor's legal expenses and costs incurred. As far as procedure, I don't know, I think I've covered what I was going to comment on.
Is there any questions from the alderman? Alderman Matichek, did you push a button?
I was picking up the mic, but
sorry.
I do have a question, though.
Go ahead.
Reading my mind, apparently. So if I get this right, we could do the recall, which would be about $20,000, or this other option of forcefully removing, and we'd be at risk of their attorney fees for the city to be represented. And then if it would be found that he guilty, if you will, and removal, he could then also sue back the city? I mean, respond in kind and sue the city for wrongful termination if he felt that within the quasi trial things were misrepresented or false statements were made?
I think the recourse or the procedure would be an appeal of the determination by the council that there was cause for removal. I don't see that there would be a cause of action, a civil cause of action for wrongful termination of a elected official.
Again, would we be hiring another outside attorney to...
Excuse me?
Would we be hiring another outside attorney to represent us in that case?
Well, somebody would have to defend it, yeah.
Okay. And then, just curious, within this, if it's found that false statements were made in the claims against the mayor, could those people be held liable within the claims for personal liability, making false claims?
Well, there's a pretty high threshold on defamation against an elected official. The higher up you go in the food chain, or the more public your position becomes, the harder it becomes for that person to sue for defamation or libel by individuals. The standard that the courts have applied for a long time is a malice standard. You have to prove that that person made those erroneous statements maliciously with intent to cause harm, knowing that they were false, and it's a pretty tough standard. So just making false statements, unless it were done or proved to have been done maliciously, I don't think. I wouldn't mean you couldn't sue for that, but the likelihood of recovery, I don't think, would be there.
Anything else, Alderman Matichak?
Not right now.
Thank you. President Ruffledge.
Thank you, Mr. Chairman. I guess a follow-up on that question. The misstatements would be made under oath, correct? If the process proceeds to an investigation, subpoenas would be issued and statements would be made under oath. So outside of defamation, there would be other issues involved.
Right, that cuts both ways. It is a quasi-judicial proceeding. That's the testimony would be taken under oath, so you're sworn to tell the truth, and you'd be theoretically prosecuted for criminal violations there for false swearing or fraud or whatever. Yeah.
Thank you.
One thing I did not touch on, and I see my notes, question has come up as to, and I don't mean to be flip on this, this is very serious stuff, but what happens if the mayor is removed? Who fills the void and how is the void filled? I've seen comments that the council president fills the shoes for the balance of the term. That's not correct. The process is under the statute, and it's statute that's close by the removal statute. It's how to fill a vacancy in an elected office for a city position, and in cities of the second, third, or fourth class, we're a second class. We're a city of the second class. In the office of mayor is by appointment by the common council for the residue of the unexpired term, unless a special election is ordered by the council, in which case the person appointed shall serve until his or her successor is elected and qualified. So the council would appoint, similar to what you do on filling vacancies for aldermanic positions. My guess is you would have a similar process where you would invite people to submit sort of resumes to the city clerk, who would submit them to the council. You'd have people come before you, maybe, and you'd consider them, and then the council would appoint someone to fill the vacancy. Could it be an alderman? I think so, if they wanted to run for that vacancy. But it could be any citizen, any resident of the city of Sheboygan would qualify for the position.
Attorney McLean, in that scenario then, temporarily would the president of the council run the council meetings or any other meetings until the council takes care of that? Is that the progression?
Yes. Yeah, the council president under our code acts sort of as acting mayor in the event of incapacity or unavailability of the mayor. So the council president would serve sort of in an acting capacity until the council would appoint a successor to fill the unexpired term.
Any other questions? I have one. Attorney McLean, in these quasi-judicial hearings, I remember back from my law and licensing days when I was chairman of that committee, when we did some quasi-judicial hearings, we generally didn't do depositions. I don't believe the city attorney, assistant city attorney, Chuck Adams, did any depositions, or I don't even believe the defense counsels did. We basically subpoenaed the people, and then they just the counsels, each counsel, the prosecutor and the defendant's counsel were able to ask questions. Is that a hard, fast rule, or are depositions a possibility in this kind of a procedure?
Well, again, there's not a whole lot of precedent. I don't think, but I would think depositions would would not be wise to permit. I don't think that necessarily depositions would be required to provide due process to all the parties. The statutes don't talk about depositions. It talks about a speedy hearing and the ability of the accused and their counsel to confront the witnesses and cross-examine witnesses. I think that's clear, but I hate to harken back to the Angela Payne situation, but that was filed a couple of years ago and had been set for hearing next week. Part of that was a lot of procedural processes, depositions and interrogatories and all that. If you want to eat up a lot of time and money, you do that, but I don't think that that's required under the due process standards for a removal proceeding.
Thank you. Any other questions from the Alderman? Thank you, Steve. Go ahead.
Just another caveat, I guess, if and when the council decides to hire counsel representing them, perhaps that's a question you would ask them as well.
Thank you. Thank you, Steve. The next item on the agenda is number 10, funding and hiring of special counsel. I see our financial director, Jim Amodio, is in the audience, and I'd like to call Jim up to answer some questions we may have regarding funding this if we would indeed decide to go ahead with this removal process. So, Director Amodio, could you step up to the podium, please? Director Amodio, from what Attorney McLean said, we can't give you a hard, fast figure, but based on what he did mention about a figure of from $10,000 up to $50,000, when we're talking that kind of money, where would you envision those funds coming from if we decided to go ahead with this?
Well, as you know, coming into the 2011 budget, we did have a contingency fund that we used to meet our budget in 2011. So our current budget does not have a contingency fund in it. My recommendation would be that if you chose to use funds, you have the authority to use some of the undesignated reserved funds in the general fund balance.
In the general fund. Any questions from the Alderman? Alderman Matichak?
And right now, if we wouldn't spend that money, what would that money go towards for next year?
Spend from the general fund?
Money?
Well, the general fund has a reserve balance in it. We're required by local ordinance to maintain a certain percentage of that in reserve in case there's emergencies within the city. But those funds can be used that are undesignated.
Follow-up?
And currently, what's the balance?
The balance is $5.4 million.
Any other questions?
Second one.
Attorney McLean?
Jim, my understanding, that would require, though, a budget alteration.
That is correct.
To move the funds from the undesignated reserves to some account to cover that.
Correct.
Which
would have to be a resolution put in.
A two-thirds vote of the council to do.
Yes.
Any other questions for Director Amodio? Thanks, Jim. Oh, I'm sorry. Alderman Hammond.
Jim, what is the level that the undesignated funds is mandated by?
Well, it's normally 18% of our next year's budget. So if we spend $35 million, it'll be close to $6.5 million. We just barely meet the threshold. From 10 to 11, we improved it from 3.6 to 5.4. We still have a ways to go to meet our 18%. But in emergencies, we can use those funds. It does at some point, if we're going out for large bond issues, could affect our bond rating, because they do look heavily at our undesignated reserves.
So at this point in time, we're not at the threshold?
Correct.
Any other questions? I think that's it. Thank you, Director Moya. The next thing I would want to discuss with the council is what action, if any, does the council want to take? Because we do have 2 verifiable complaints here. What action, if any, do we want to take to remove the mayor from office? And I'll open that up for discussion. President Rindfleisch.
Thank you, Mr. Chairman. I was expecting a bit more conversation at this point in time from fellow alderpersons. The vote was 14-2 last time, asked for his resignation. I believe, though, that wasn't based upon politics, budgets. It was based upon a feeling of responding to their constituents. I think in most cases, those that voted 2 against and those that voted 14-4, that motion were responding to the constituents. I don't hear anything in this conversation right now that would lead me to believe that the constituents would change their mind. Any actions that we take today obviously would have to get voted upon by the Common Council. It does give us a few days of, if we make some motions today, to hear back from our constituents to either alter our course or look at some other options that way. The phone calls that I've received basically involve do whatever it takes at this point in time. So my goal is to maintain that, and I will continue to do that.
You're saying anything that it takes for removal?
Right. I'll make a motion at this time if no one else has any ideas, any thoughts. Motions would be to proceed, motion would be to recommend to the Common Council to proceed with the formal removal process. Furthermore, the motion would be to direct, the whole president, Common Council president, Common Council vice president to interview potential attorneys. And the third resolution would be to a budget resolution to use undesignated funds to fund the hiring of the attorneys.
I'll second that.
We have a motion and a second. Can't take shorthand, so.
I don't either, so you may want to read it again.
Well, there's nothing written down, so I'll have to go again. The resolution, your feedback. Resolution would be to direct, to recommend to the Common Council to commence the formal removal process. Furthermore, to direct, council leadership to interview and hire the 2 attorneys, one for the council and one for special prosecutor. And furthermore, because it's a budget item, to move the undesignated to
create a resolution.
Create a resolution to move from undesignated funds, the funds necessary to hire the attorneys.
Undesignated funds to
move from undesignated funds the funds necessary to hire the attorneys.
We have a motion and a second, and now we're under discussion. Alderman Hammond.
Thank you, Mr. Chairman. I guess I would just offer maybe a friendly resolution based off of what Attorney McLean had indicated. Maybe the first step would be to hire just the council representative, the attorney representing the council, get his or her feedback as to what Attorney McLean presented in the process, and then determine from there whether a special prosecutor is necessary. So I guess I would just offer that as a friendly amendment.
President Rindfleisch.
Thank you, Mr. Chair. Not opposed to that amendment. Trying to, though, of time of a speedy hearing, as Attorney McLean had pointed out. I guess that would be the intent, but at least the resolution would be there that if we need to proceed, then it's been allocated at that point in time. But Attorney McLean's point on speaking with our own counsel about the validity of the specific charges now, I think it's important to do first. So I agree, but that would be within that picture.
Also, President Rindfleisch had asked a question before I would make a motion, a friendly amendment. Do you think it would be a good idea to possibly put a cap on the transfer, and then as we go, if we go along in this process, maybe just hypothetically, if the cap was $50,000, that we get a report back from our council when we maybe reach $40,000, because I know some lawsuits in the past with the city, we've ended up with a big legal bill surprise, and I'm just offering that as thought of possibly incorporating that into your motion to have a cap in there, that whatever the cap is, and then perhaps when we get three-quarters there, get advice from our legal counsel as to where, the clock is running on how much we spent and how much we have to go, and then we also can evaluate where we are in the process at that time.
Again, not opposed to that as well. The motion is meant to be a motion from the body, so the will of the body. So I would accept that motion.
I'd make a friendly amendment to put a cap on the expense at $50,000 with a report from our council when we've reached the $40,000 mark. Make that friendly amendment.
Second.
And then, of course, the document that comes through for the meeting on Monday night would reflect the transfer would be a transfer of up to $50,000. Sue, what's the procedure? Do we have to vote on my friendly amendment? It's been seconded, or?
Well, it's a friendly amendment. I think that we incorporate that in the one before, but my question would be, you said that you wanted to have the leadership interview and hire 2 attorneys. You got that, plus then you've got, let's do another friendly amendment that says let's just hire 1. So which one do you want to? One says 2, one says 1.
Alderman Hammond?
I don't think my button's working, sorry. Maybe, again, just as a suggestion, we can certainly authorize the leadership to hire up to 2, up to 2, and that might solve that. But again, I think at least initially would hire 1. I would just also like to make a comment about the cap, keeping in mind that it takes 2/3 of this body to, if we cap it at $50,000, it takes 2/3 of this body to raise it a second time to authorize more money. So instead of putting a cap on it, again, a little bit of a friendly amendment would be maybe to appropriate whatever's needed, but then the council can dish it out after review at $40,000. Put that in writing.
I would go along with that.
That's your amendment now.
I would withdraw mine and go with Alderman Hammond's. It's not put a cap on it, but review it at $40,000. If it gets that much, if it gets to be that much.
I'll withdraw my second and second the new motion.
Thanks, Jerry.
Is there any other discussion from the alderman? Alderman Matichak.
I just want to get this clear that tonight we hear about from the fire department how they may have to close firehouses, risk lives by cutting time so that they can respond to, and we haven't made our threshold for next year's budgeting. So that money is going to have to come out somewhere. Basically, we're ensuring making cuts, such as closing the firehouses and whatnot, to pursue the chance of removal. And then even then, we don't even know for a fact that it's going to be for sure removal when we have the option of a recall, which would limit the city's liability and future spending of the removal of the mayor. if that's truly the will of the people.
Thank you, Alderman Matichak. Alderman Heidemann.
Thank you, Chairman. I don't want to get a lot more phone calls on this. I get enough comments during the day, but my phone is not ringing off the hook as far as whether they're for or against getting rid of proceeding to take Bob from office. I guess I would think that spending $50,000 on something that might resolve itself in a year and a half might be a waste of our money. So I'm not going to support spending any money to try to get the mayor out of office, though I did and would have liked to seen him resign, and I voted in favor of that. I have trouble spending our hard-earned tax dollar on something that might be alleviated, or there might be the other option of the recall. I guess I'd rather see that come forward and limit our liability to that. But so I can't support a $50,000 cap to go against the mayor.
I think the current motion on the floor is that there's no cap.
Okay. Well, even spending any, I don't want to spend one dime on doing that. So.
Alderperson Kittleson.
Thank you, Chairman. Just to ask, though, those undesignated funds are for emergency. You wouldn't use that money to fund the fire department anyway. So those are monies put away, for emergencies. Just to make that clear, I think that's correct. Am I not? Am I right in that? Thank you.
I think Director Amonio.
We used undesignated.
You'd have to step up here.
The city in the past 10 years, probably 6 to 7 times out of those 10 years, has used undesignated fund reserve balances to fund expense budgets for the city. So we do use that. So in your example, if we wanted to fund the fire department an extra $200,000 or $300,000 and the council approved it, we could do that.
Any other discussion? Alderman Matichak.
So once again, that money could go to saving the fire house, or it could go towards pursuing this.
If the council so chooses, that's correct.
Thank you, Alderman Matichak. Any further discussion? Alderman Sampson.
Thank you, Mr. Chairman. I don't believe we're at an issue here where we're deciding on keeping or closing a firehouse in order to pursue this matter. I think those are two completely different issues. So we're not choosing to close one or keep one open just so we can pursue this particular situation.
Thank you, Alderman Sampson. Alderman Hamann, I think you're next. Oh, that was from before. Thank you. President Rindfleisch.
Thank you. I guess to make it clear, to respond to Alderman Heidemann, I don't want to spend a penny either on this. The actions taken weren't taken by me. It was taken by the mayor. And the responses that we took last time in the 14-2 vote wasn't a response that we took lightly. It was a response to the mayor's actions. And it's a response to the comments that I'm receiving on the street, at home. And I'd rather not spend a penny either. But we asked the mayor to resign. He did not. He publicly stated that he will not do so. By not doing anything, I think we're granting approval for the behaviors. I think we're granting acceptance that for the next year and several months that we're okay with what had happened. And quite frankly, I don't think that's acceptable. I think we have no alternative because the mayor has forced us into the situation.
Thank you, President Rindfleisch. Alderman Heidemann, I think you and I probably qualify as a couple of the biggest penny pinchers when it comes to the taxpayers' money on this council. I have to tend to agree with Alderman Rindfleisch. Based on the calls that I've been getting from District 4, I've been getting the same volume of calls for removal as perhaps you, and I don't want to spend a dime either. But under the circumstances, we asked the mayor to step up, man up, and resign, and he refused to do it. So this leaves us basically with no other alternative if we want to move forward with this. But I agree with you, Joe. I don't want to spend any money either, but under the circumstances, if we move ahead with this, we don't have any choice. Any other discussion? Okay, with no further discussion, I believe we're ready for a roll call on this. Is everybody clear what we're voting on? Sue, can you go through it
I can
briefly?
kind of generally go through it because I've got it on tape. Basically, there was a motion to recommend to the Common Council to proceed with the formal removal process. In addition, to have the leadership interview and hire up to 2 attorneys. In addition, to draft a resolution for a budget transfer using undesignated funds, and to have those undesignated funds with no cap, basically, and the reporting by the legal counsel that's been hired when it gets to be $40,000, and then advise future. Is that basically what you all said?
Attorney McLean, does this take a simple majority or 2/3?
It's just a recommendation.
Just a
It's just a
recommendation.
recommendation of the council, simple majority? Okay. Madam City Clerk, would you please call the roll?
Carlson?
Aye.
Decker?
Aye.
Hammond?
Aye.
Hammond?
Aye.
Heidemann?
Nope.
Koth? Aye. Kittleson?
Aye.
Matichak?
No.
Rindfleisch?
Aye.
Raisler?
Aye.
Sampson?
Aye.
Van Akkeren?
Aye.
Vanderweel? I'm sorry, she's gone.
Aye.
Belt?
Aye.
And Boren.
Chair votes aye.
12 ayes, 2 noes.
The next thing on the agenda, it passes. The next thing on the agenda is to set the next meeting date, and that will be determined depending on referral to the committee of the whole. I will entertain a motion to adjourn.
So moved.
Motion and second to adjourn. All in favor? Aye. Opposed? Thank you, everybody.